On the question of the agenda, let me just open one subject that we might otherwise overlook, which is standing, which is access to courts. And I think that's a kind of canary in the mine in terms of the agenda of this group. And I think a really key moment and easily overlooked was the Chief Justice's dissent in Massachusetts against EPA, the global warming case. He dissented on the key threshold issue of whether the state of Massachusetts had standing to bring this lawsuit. Okay, one could argue that because the court had not before given special standing status to states as states. That was new law that Justice Stevens announced in that case. But it was the actual tone and words of the Chief's dissent that kind of show you what's afoot. He said, this is scrap is back. This is the recrudescence of scrap. So scrap, what was scrap? You all, some of you were too young to remember scrap, but that was a sort of high watermark of standing in environmental or public policy cases, you know, from the 70s. In fact, from the era in which John Roberts came into William Rehnquist's chambers to be his law clerk, and it was a battle that was really hot then and had kind of receded, and it just had the sense that the Chief Justice's view of this matter was formed at a very young age, and he really learned at his master's knee, and here's something that he lost this particular battle, but is as clear from the Hine, the freedom from religion, Flast against Cone, taxpayer standing case. I mean, that's not going away, and and the other access to court issues, some of them seemingly rather petty. What was the name of that case? Bowles against Russell, I guess, where the court overturned 2 precedents in order to say that, you know, this guy was out of court because he filed his notice of appeal 1 day early, according to what the judge had told him, but 3 days late, according to what the statute said. You know, they went out of their way to grant that case and overturned 2 precedents in the course of deciding it against the plaintiff, appellant. So I think we really have to use these standing cases as a marker for the goals and the achievement toward those goals of the conservative majority.
I agree with you, and I think the standing doctrine is a good example of what gives me pause about Stewart's prediction and pointing out the differences that we're seeing in this right bloc. I think you're right. Roberts and Alito are not up for just summarily overturning you know, precedent right and left. But I also think that Roberts in particular, he thinks he has some time. I mean, these guys are going to be in control for a while, presumably. And it seems to me a much sort of better way to proceed is to do it incrementally. Roberts will eventually, presumably, achieve the kind of unity he claimed he wanted at his confirmation hearing, because over time you build your own precedent and you're relying on your own stare decisis, and you don't have to be as aggressive. And so if they're right and they have this kind of longer time horizon, then the difference in tactics between the kind of very dramatic overturning that Thomas and Scalia in some instances are in favor of and the Roberts-Alito position, it kind of melts away. And, you know, if I were on the right, I would think that would be quite an attractive proposition. And we may very well see exceptions to that, I think. I hope that, and I would like to think that Stewart is right about the national security case that were like Boumediene and Al Odo when they come down next year. But I think the reason that there may be differences is Justice Kennedy. And in terms of thinking about, you know, the legal landscape more broadly, it gives me pause to think that it's all hanging on Justice Kennedy.